We moved to Beaufort County.
Not everybody's here from the county, but well, we've got
I
Libby.
don't think I'm on his
Well, everybody
Christmas
rise
card.
and just please join me in the Pledge of Allegiance. I pledge allegiance
To the flag of the United States of America and to the republic which stands
which it stands,
one nation,
one nation,
God,
under God,
indivisible,
indivisible.
and justice for all.
Thank you. We have guests on. Okay. All right. Hang on a minute. I get my agenda. We have a big agenda tonight, so let's just start with the usual FOIA notification, which I know has been put out there. We have minutes for approval from June 7th, 2021. Are there any amendments that anybody would care to make?
Ed, I'd like to make one amendment. Williams, the part where Williams Smith spoke in favor of involving students, school students, juniors and seniors in the plan. That was something I brought up in a meeting, I believe, back in May. And he also stated at that time, at the June 8th meeting, that he was very disappointed that we did not include the schools in the comp plan for their comments. And I was disappointed because that was one of the points I brought up. And I feel it should be included in the minutes that he was disappointed because what he said reflects on us, and who knows who he went back to in the school system, his friends, his neighbors, and brought up how disappointed he was. So I really feel that his disappointment should be included in the minutes, because he did state that.
Okay. Is there any objection?
Who was it again? Who made these?
William Smith.
William Smith.
Is he not on the school board?
He is.
Yes, he's one of the.
From St.
Would it be
Helena
appropriate
Beaufort.
for him to take it to the school district?
Well, I don't think that's the question. I think the statement that it wasn't, his statement wasn't included in the minutes.
Gotcha.
Okay, with that amendment in mind, and I would ask that you help.
Was it on the video? Like, did anybody watch the video? I mean, I'm assuming
Yeah,
that.
that's where.
I mean, I remember
Yeah.
it.
That's
It's on
where,
the video.
If he made the statement, then it should be included, yeah.
okay. All right, with that amendment, do I have a motion to approve the minutes?
I make a
Cecily?
motion to approve the minutes.
Well, we'll give you a second, so Cecily, her hand up.
I don't think Frank can second
Absolutely.
because he wasn't here.
Okay,
I
I vote to
second it.
approve, yeah.
second, all right,
It was
all
a tough
those in
meeting.
favor?
Yep.
Aye. Any opposed? No, okay. Thank you.
You're
Thank you, Frank.
Hey, girl.
All right. Any questions on the agenda? We've got a full agenda of seven items tonight. Anybody have anything that they'd like to say, add to the agenda, delete from the agenda? Okay. Hearing none, agenda is approved. Okay, the portion of the meeting here is for public comments, limited to 3 minutes for any subject not on the agenda. Subjects that are not on the agenda. Are there any public comments on subjects not on the agenda? Hearing none, I'm going to move forward. First item up is a text amendment to the Community Development Code. Quite a few sections that can be modified as outlined to update the definitions, regulations, and procedures for signs and sign permits. Rob?
All right, well, thank you, Mr. Chairman. What we have, the first item, is a series of amendments to our sign regulations. In Article 5, our procedures for signs in Article 7, and then some of the definitions that are in Article 10. And I would say, in general, sign regulation is one of the most intricate parts of land use planning and zoning. And one of the most significant issues is how it relates to free speech. And there's been a lot of case law recently dealing with sign regulations. And so we wanted to make sure that our sign ordinance, was resilient to, challenge based on, constitutional issues. And so we hired an attorney from the Chattanooga area, Scott Bergtold, and he kind of looked through and made some comprehensive changes to the sign regulations, specifically looking at articulating more fully the basis for regulating signage and the legislative record supporting such regulations, modernizing the standards and procedures for regulating signs, and adopting new and updating older definitions applicable to signs. None of these really affect the fundamental issues like size, location, color, those types of things. They more have to do with making sure that our sign ordinance is rock solid as far as any kind of legal challenges. So I was going to hand the floor over to Scott Bergtold, who's joining us via Zoom, and he can kind of go through each of the amendments with you. Okay.
Thank you.
Good evening, Planning Commission members. Can everybody hear me okay?
Yes.
Okay, fantastic. Yeah, as Rob was saying, we basically have made a series of changes in 3 portions of the Community Development Code that relate to signs. The first one I want to talk about is Article 10, definitions. There were a number of terms that were used in various places in the sign regulations, the substantive sign regulations that were not defined. So everybody seemed to operate as though they know what the terms mean, but we thought it best to have explicit definitions in the code. So we've added relevant definitions, including those for commercial billboard sign, commercial message, what a digital display is, what an off-premises sign is, an on-premises sign, and so forth. We've also updated some other sign definitions, including definitions of directional sign, landscape wall sign. Again, we're constantly looking at this area of law that is in flux, frankly, and wanting to make sure our sign code ordinance definitions are up to date. And then we also made some distinctions and some changes to Division 7.2, specifically 7.2.40, to match what the county does in practice, and that is it distinguishes between a preliminary approval for a sign and then a final approval of a sign permit. The preliminary is when you come in and you say, this is the sign I want, and these are the standards that are applicable to this district or what have you, or this kind of sign. And the county would give a document, and then the constructor has to go out, the applicant has to go out and build that sign, and then they would get really the final sign permit was after it was approved. So the code has been updated to reflect that, and also to specify the information that is necessary to make a sign permit application complete. We also laid out more clearly the timeframes for county staff to be processing applications, and set forth the procedures for denial or revocation of a sign permit. And if someone decides to take an appeal from that, we kind of explicated the procedures a little bit more carefully in Division 7.2. And then finally in Division 5.6, like Rob said, we kind of detailed the county's substantial interest in controlling signage, including reducing driver distraction, fostering pedestrian and traffic safety, and also serving, obviously, the aesthetic needs of the community. There's a lot of judicial decisions that we've identified, what the scope of that legislative authority is that relate to signs, and then studies that support these governmental interests. Those are included. They've been provided to the county council. There's a lot of them. There's lots of pages involved, but essentially they reinforce what the predicate of the county's sign regulations had always been, which is having too much visual clutter or distracting displays, increases public safety risk and also deteriorates the aesthetics of the community. And so we've identified also certain signs that are exempt from regulation or from the permitting requirements. We've also reinforced what the county has had for some time, which is a prohibition on new commercial billboard and digital displays in certain locations. And then finally, we've elucidated a policy that was pre-existing in the code. We've made it even more explicit, and that is a substitution policy whereby non-commercial messages may be substituted for commercial speech wherever commercial speech is permitted or allowed on the sign. Basically, those are the types of housekeeping amendments that are involved in these code amendments, and I appreciate you being willing to hear me out from a distance.
Thank you, Scott. Questions?
I have a question. What impact will this have on existing small businesses now? Will they be forced to change their signs?
No, there's nothing in these provisions that does that. I think small businesses will basically be conforming to if they were conforming to the regulations before they were adopted, or before they are adopted by county council, assuming that they are on third and final reading, then whatever signs were permitted and lawful before, those will be grandfathered per se, and be allowed to stay subject to the restrictions on non-conforming uses, because a sign can be a non-conforming use. But if someone comes in, let's say next week, or the week following the final adoption of these amendments, then they would just have to comply with the amendments that are presented here tonight. So they'll old ones will be grandfathered in, new applicants would have to comply with the code requirements, but they're not substantively or radically different from what has existed in the code already.
So if somebody came in, let's say an inspector came into a business that's already existed and says your sign doesn't conform, how does that business prove that they've been grandfathered in?
Well, they would usually produce the permit that they received when they applied for the sign and got approval from the county in times past. That's usually what they would do, or they would do a FOIA request and ask the planning department for the records on that location, and then they would get it that way.
Okay.
Other questions? Stephanie?
Thanks. I have a question on the section division 5.610, and it's under the letter B, applicability scope. So I guess I don't understand why under number 1, the third sentence was stricken. These sign regulations apply to all signs within the county. I just want to confirm that we're passing an ordinance or policy that all signs in the county, that it's not up to the town of Hilton Head or the town of Port Royal. I mean, the county is the authority. Is that correct? So I don't know why that was stricken.
Well, I can, tell me what page you are under 5.6.
Let's see, it's Division 5.610. My document here doesn't have a page. I mean, it's what you all sent me, so.
Oh, it's 5.610. Is it A1 or?
It's B. It's the letter B, and it's called applicability scope underlined, and it's number 1, B1. And the sentence begins, the provisions of this division, blah, blah. But what you have stricken is the last sentence. These sign regulations apply to all signs within the county. So my question is, why was that struck? Because that seems to be important.
Because we replaced it with the language that's underlined that says the provisions of this division shall govern the number, size, location, and character of all signs allowed under the terms of this division. No sign shall be allowed except in accordance with the provisions of this division.
That seems kind of complicated because, as Mr. Ducey was saying, like, what exactly is the plain language here?
Yeah, the reason that we did that is because it was a little bit circular, because it says these regulations, it used to say these sign regulations apply to all signs within the county, but there are some regulations that are exempt altogether. So if you look down under
I saw that.
B4,
Yep.
there are some signs that are exempt from regulation. So on the one hand, one says, here are all the regulations that apply to all signs within the county. But then down below, there's a whole section on exempt signs that aren't regulated at all. So the substitution language in 1 is the exact same policy. It's just a little bit more clear, so that when someone gets down to sub 4, they don't wonder why why 1 says that everything's regulated and then 4 says, but these signs aren't regulated.
Yeah, and I just wanted to clear up, these our sign regulations do not apply to Hilton Head or, to the municipalities.
So it's not, so that's actually an untrue statement. It doesn't.
I think that's a very general statement, and I think it's better stricken because they only apply to the unincorporated areas of the county.
Okay, great. I never saw, I mean, I read this a couple of times, so I never saw anything else that said unincorporated areas of the county. I never saw language that distinguished between municipalities and their restrictions, because I thought the county was the arbiter. That it simply is not true, is what you're telling me tonight.
We only have jurisdiction over the.
Great, okay, so I guess I'd like, and maybe I missed it, but, and I'm not a small business person with limited amount of time, but that seemed to me to be complicated.
Okay. That raises a question that I had. You go down 170, on the right's Jasper County, on the left's Beaufort County, if you're headed west. I see a lot of signs on the Jasper side, include, new digital signs and so on. I don't see so many signs on the Beaufort County side. How do, the concerns of public safety and so on, I mean, you're only safe if you go west and not east. I mean, what have we done, or have we done anything to try to get some intergovernmental agreements on signage on major roadways, particularly 170, which is becoming more and more populated with businesses. Down in the Okatee area, down toward 278, there's a new strip mall going in or something. I don't know what it is yet. So it seems like this is a great attempt on the goals for safety and efficiency, et cetera. But it seems like a split decision on major roadways where you've got multi-jurisdictions, same as if you go through Bluffton. Suddenly you're not, I don't know if everybody knows the borderlines of Bluffton or Jasper County. So I see them one side, I don't see them the other. How do we rectify those differences?
Well, I would just say it's a lot easier to control signage in our jurisdiction and, to work, controlling what happens in Hardeeville and Jasper County means working cooperatively and trying to, have our standards match each other. And I can get back with you on that. I believe that they do have some more stringent sign standards now, but they're dealing with all the existing signs.
Well, that's good to hear. As long as we can move in that direction. I mean, for the goals that you've got, it's perfect. I mean, it's the direction we want to go in. But I see an inconsistency in jurisdictions that I know there's inconsistencies in a lot of different issues. But this one for safety, public safety and so on, and the average person not having an idea that they're driving through on one side of the road, one county, and the other side of the road is the other county, or the jurisdiction starts at the next block. Anyway, you know the issue. I would appreciate whatever actions we are doing to undertake to analyze what we can do to pull them together. Another question that I had was on, and this is up to you, Rob, at this point. The digital display may not change any more frequently than every 30 minutes. Again, I've seen once, I guess this is Jasper County, that flashes every 10 seconds, different display on it.
Right, most of them do.
I don't know of any others that do in Beaufort County. I haven't really done a survey on that. What are we going to do, again, for the element of safety? People should be watching all the signs blink on and off and, oh, what did that say? Which happens. Are we doing anything to alleviate that potential grandfathering of some will have now, the ones going forward, 30 seconds, and the other ones will have.
Well, fortunately, there's no digital billboards in Beaufort County within our jurisdiction, so we're not dealing with any.
Okay.
The one sign that I'm aware of is in Jasper County
Right.
on 170.
Okay,
No,
so
I
it's
agree.
not an issue for us in Beaufort County at this point.
I was at the council meeting when the fellows brought the electronic signs and set it up on display outside about a year and a half ago. And at that meeting, they said that they would give Beaufort County 5 electronic signs to flash warnings, hurricane, and hurricane evacuation routes and all of that. And I thought that was a great idea considering what happened after Hurricane Matthew and the chaos that we had involved. And that's one reason, where I think electronic signs should be allowed, or Beaufort County has to do a better job in putting up their own electric signs, warning people for evacuation routes following this way. So that's just a point I
Yeah.
thought I would make.
I think council was concerned that maybe 1 out of 8 flashing signs might have that safety message, and the others are going to be.
Well, I would have said, no, it can't be that way. It has to be dedicated solely to, to disaster, or whatever.
Rob, if I could weigh in on that real quick. One of the amendments that we have made, or that we're proposing under 5.6.10B4, we added a new C, a category of exempt signs that says wayfinding, directional, hazard, life safety, traffic control devices, those that are installed or required by our government agency on private property. So we do have a provision where if we needed to alert folks, those types of signs would be exempt from these regulations.
I saw that, and that's why I brought up the electronic signs again, because you do have that section just for that purpose.
Okay.
Thank you.
Anything else, Frank? Anybody else, any other questions? I applaud the work that's gone into this. Some of it's a little legalese intended, it looks like, but with all the quotes and the laws that pertain to it. But I applaud the amount of work that's gone into this by Scott and by the staff. Thank you.
Yeah, I will say I've gone to sessions on sign law, and it's a very specialized
Yeah.
area of land use law, and I'm just thankful that we have somebody, who is able to kind of wade through this and help us, strengthen our ordinance.
Well, Commissioners, I also want to note that we've been working with Tom Kevaney and the County Attorney's Office, and obviously Rob and Eric and Hillary and everybody in the Community Development Department, and it's been a pleasure to work with them. A lot of hard work has gone in on the part of staff, and I think we're moving in a good direction.
Thank you. All right, may I have a motion to approve the amended sign
So moved.
procedures?
Could I ask one question quickly first? I'm sorry.
No, go ahead.
On page 12, regarding the digital displays, as far as gas stations and theaters, are they allowed to display just gas prices, or is that a digital display that's allowing them to advertise other items?
It is a location-based restriction on digital displays, or an allowance in that case on digital displays, but we don't regulate the content. Normally, what's going to be displayed at that location is going to be a price of gasoline, and that's what we envision there. But the courts are really careful in holding local governments to making them toe the line on not regulating the content. But we recognize there's things that change frequently, like gas prices. And so that's why there's an exemption on the digital display prohibition at gasoline stations.
Is there a size limitation? I don't really see, maybe I missed that.
Well, there would be other size limitations that apply within the district,
Okay.
according to whatever district it's in there. So there would be height and size limitations on the sign, but those are separate from the type of sign with the digital display.
Okay. Thank you.
Okay, any further questions? All right, we have a motion for approval. Do I have a second?
I second it.
Frank, second. All those in favor of the motion to approve the text amendments to the definitions, regulations, procedures for signs and sign permits, please raise your hand. Any objections? Approved unanimously? Thank you. All right, we're ready for the next item.
Thank you.
Thank you,
Thank you.
Scott.
Thank you.
All right. Zoning map amendment for 3.09 acres on Laurel Bay Road, 374 Laurel Bay Road from S1 Industrial to C3 Neighborhood Mixed Use. Applicant John Walker. You want to start, Rob?
Yes, sir. This is located in Port Royal Island on Laurel Bay Road. It is just to the west of the intersection with Bay Pines Road and Laurel Bay Road. The parcel is actually located on a frontage road, which you see that is along Laurel Bay Road called Zem Lane.
Right.
And it is 3.9 acres. And if you look at the map that's enclosed in your packet, it's currently zoned S1 Light Industrial. And if this area looks familiar, I think less than a year ago, the Planning Commission took, I think it was last fall, we considered an amendment to that orange area that is above this, the four parcels on the corner of Bay Pines and Laurel Bay Road, where they went from S1 and rural to C4 community centered mixed use. That was the gentleman who was interested in doing affordable housing. And one of the results of that, well, there's two things going on here. The applicant under S1 light industrial, it does not allow single family houses. And so we have several cases in the Burton area in particular where somebody is zoned S1 light industrial, and it may make sense on a larger future land use framework that area be light industrial. But the property owner just wants to build a house there. And currently the district does not allow them to do that. We've had several rezonings that have, either went from S1 to rural or to C3 so that somebody could simply build a house. In this case, this is accomplishing that, but in addition, this property, because of the last rezoning, it kind of was a little 3 acres of industrial surrounded by other zoning districts. This will allow it to be similar to the zoning that is, further west on Zem Lane. So, as far as, we believe that this is consistent with the comprehensive plan, 3 acres of light industrial, kind of in a standalone property is not very effective in that area, but, if it is the wish of the property owner to build a house, and that's a similar use that is directly to the west, staff, we feel that that's very much consistent, with the other development in that area. It's really kind of straightforward.
Light industrial.
And I'm not sure if the applicant is here. Oh, yes. Do you want to speak or?
I will be prepared to.
Oh, okay.
To speak, but,
You're welcome to come up and speak
Or
if
if they
you,
have questions.
Okay.
Okay.
just tell us your name and so for the record.
Hi, my name is Contoya Simmons. I'm purchasing this property from Mr. John Walker. I would like to put a home on it. It's something I did for me and my son, something I can leave behind for him, and it's the perfect, ideal area. I love it out there. I've been living on Island Tank Road for the longest now, and it's right around the corner, so it's perfect. I'm used to it. It's there, and I would just like to have it so I can put a home on it.
So I take it you have a contract pending on this property?
Yes, sir. Yes, sir. Pending approval.
Okay.
Yeah, maybe, I don't know if you know the answer or Rob. What is behind this? I'm looking at a satellite map right now.
It's supposed to be the affordable
I
housing.
don't know, it looks like a salt mine or something.
It's a rock crushing yard.
So rock crushing,
Yeah, I think it's a laydown yard for a contractor, but I know that
Okay.
was supposed to go away because somebody had purchased that property to build housing.
Oh,
yeah, there's a lot of pieces of, big piles of broken concrete there and a lot of heavy lifting equipment.
Let me do one thing if you don't mind. Who is on the Zoom call on their phone? Can you identify yourself, please?
Josh Stone?
Can you mute your phone, please? We can pick up your conversations through our meeting.
I apologize.
Thank you.
Thanks, Eric.
Oh, go ahead, I'm sorry.
Yeah, it's a laydown yard for a construction contractor.
Now, that was the one that's the property that was rezoned,
Yes.
and now is it under contract for,
I'm not sure of I'm not sure of the status of that particular property. But that's what the rezoning that we considered 6 months ago is for housing in that area.
I guess my concern is, and I wish you a lot of luck building this house and everything, and I really hope this works out for you, is if that's right now pre-existing non-conforming, right? Because the zoning that property behind the property the lady wants to purchase, that, whatever this is, has got to be cleaned up, correct, at some point in time?
There's nothing to clean up. It's an operation that takes concrete and turns it into crushed rock.
But it's zoned community center mixed use.
yeah, and it's
I
not,
know you can't come in and rezone a piece of property and then continue to use it in its old use. This has nothing to do with you, ma'am, nothing at all to do with you, please.
thank you
Yeah,
very
and
much.
actually, the use is grandfathered, so they could continue to
No,
have that use
you're kidding.
as long as they don't abandon it, and as long as they're not changing the use or expanding. There are limitations on that, so.
So this lady will be
That's
building a house that's right, abuts a gravel
Crusher
yard.
site, yeah.
And I don't know what you call it, but big piles of concrete that are, 20, 30 feet high all over the place, and big heavy loading equipment, which makes a lot of noise. And there's a commercial building just to the left of that, as you go down that little side road. That I think is part of that complex.
Yes, it's part of the land that was rezoned.
So there are no plans or at this point to convert that piece of property, or there are?
No.
The plan was for that to be a low-income housing tax credit development. What I'm not certain of is the status of that project, because that takes, applying for the funds. I don't, we haven't seen anything in our office in terms of preliminary plans.
I had the same concern, only because now that we know that there's a single-family dwelling to be on that property, make sure that the lady knows the conditions that might prevail behind her.
Yeah, I'll be honest, that's my concern, and if we gave this owner here a zoning change, right? The whole idea of doing that was to bring it all in line, because it's rural behind it, right? To bring it all in line, everybody kind of agreed, yeah, this probably should be residential or some type of mixed use out there. He's got a certain amount of, you don't get a zoning change and then say, yeah, but I'm gonna keep going for 10 years, and maybe 10 years from now I'll close down the place and then I'll, the zoning change is just like a variance or just like a building permit. You get it, but it's only good for a certain amount of time. It's not unlimited.
No, in terms, zoning change is a change to the map, and so as long as it's.
Oh, good, then
approved by
it's a
council,
change to the map, so he's not conforming,
He will be non-conforming.
and he should be told that.
Yes, but we have certain restrictions for a non-conforming use, but it doesn't mean that it goes away unless they abandon it. I can look into the issue, but from my opinion, I don't think that should disadvantage the person who, on Zem Lane, about them wanting to downzone their property to
Well,
C3.
I certainly agree with you. I'm sorry, I forgot your name, ma'am, but if she's intends to build a home on that piece of property, which is a nice piece of property, nice looking piece of property, and she needs to understand the condition that currently exists is a non-conforming condition that's going to perhaps impact her use of her property in some way and the enjoyment of her property. Anyway, if you would just check the status of it and let us know. Are there other questions? Okay. Can I have a motion to approve the zoning map amendment for 3.9 acres for Old Bay Road.
Oh, do we have any comments from the public on this?
I'm sorry. Well, there are interested parties. My error, sorry. Sir, please identify yourself.
I'm Dr. Carlos Williams. I pastor a church across the street from the property.
Yes, ma'am, sir.
I just had a question. That particular property, she's planning on building a house there, or is it like mobile home? I mean, what is it? Because I'm wondering about the value of the property. We have lot 7 and lot 6. And I'm just wondering if it's going to affect the value of the property if it's mobile home or if it's a house. I was just wondering.
I don't think we, sir, I don't think we can answer that question for you. That would be for you to have a discussion with the prospective purchaser and/or the property owner, current property owner, to voice your concern. But we're just, at this point, all we can really do is approve or disapprove of the rezoning so that it enables her to build the home that she's expressed. All right, thank you for coming forward. I would encourage you to have a conversation with her and/or the property owner.
Yeah, so if the property is rezoned, whatever, and this is a key component for you all, and something that I have had talked to the council about for the last 2 meetings, is that whenever you rezone a piece of property, whatever's happening on that property can continue to just keep on going. And once you rezone it, people can stand up here all day and tell you they're going to do something with the property. But in reality, once you rezone it, they can do anything that zoning district allows them to do once the rezoning is approved. So they can stand up here and say, hey, I'm going to put a nice commercial building on there, and I'm going to continue operating the way I was. I don't want to be grandfathered anymore. And if you rezone the property, it opens it up to a wide array of uses. So to answer the gentleman's question, she says that she is going to build a house. You can take that on face value that she's going to do that. But if the zoning district allows for a manufactured home, then she would be able to do that as well. Generally speaking, rezoning one lot to put a residential dwelling on a piece of property, whether it's a house or a manufactured dwelling, would not have a significant impact on the value of adjacent properties, because you value and appraise properties based on that particular use on that particular property and comparable uses in the area. So a church's appraisal would be based on other churches' value in an area in a similar situated setting, not based on it's a church with mobile homes near it or a church with houses near it. So does that make sense? Mm-hmm. You have to have comparable like uses to judge the value of property.
So community center mixed use allows for different uses of that property, of which one is the residential home.
That's correct.
And any of those other uses could be allowed under the code.
And Ed, I'm not as concerned about what the lady wants to do with her son and put a house on there, because there's trees on there now. So, whatever she does, she's going to improve that. She's not gonna, she's gonna do whatever it is within this new zone. My problem is that, and I kick myself that I voted. I never would have voted for a zoning change to allow a guy to keep a quarry going for 10 months, and this is crazy.
Well, I wanted to,
It's not a quarry, though.
Well, cement crushing, whatever we want to call it,
echoing what Eric said, he's allowed to continue that use. We did check, and I checked with Libby, that the applicant has applied for a low-income housing tax credit project, and that project is active in the state and it's being considered. Okay. So as far as we know, their intent, that rezoning we considered 6 months ago, that they're still pursuing that. Okay. So, in the meantime, they may be, I'm not exactly sure what arrangement they have with the business that's on that site. Mm-hmm. But it looks like they are continuing with what their original intent was for that property.
Yeah. Okay.
All right, thank you, Ron. Are there any other interested parties on this particular issue before we take a vote? Okay, we had a,
I have a quick question.
yes,
Do we even have a second? I mean, is the floor open for general questions about this project? For example, Metropolitan Planning Commission will consider this rezoning request at their July 19th meeting. So I guess I don't know who's the driver here. Are they going to look at our decision and that will affect their decision? Or should we wait and is their decision, affecting ours? This may not be exact, I mean, this may happen a lot. So
Yeah.
I just want some clarification.
their decision doesn't necessarily have to affect ours doesn't necessarily have to affect them. This happens all the time where there are some issues that are looked at ahead of, before it comes to us, and some that are looked afterwards. I think this was just basically for some more information.
Got it.
Maybe look at it a little bit differently, representing with the municipalities.
And the annexation question, which is sort of in their court.
Yes.
Right.
Right, exactly.
Okay, so this happens a lot and it's,
Well,
we proceed.
it happens often enough in this
yep.
part of where their municipalities and Beaufort County work together through the Metropolitan Planning Commission.
Good, okay, thank you.
So I think there was a motion that was accepted to approve it. Didn't somebody?
Yes, sir, I did.
Do I have a second?
I second it.
Frank seconds it. Okay, any further discussion? Okay, hearing no discussion, all those in favor of the zoning map amendment rezoning request for 3.09 acres at 374 Laurel Bay Road from S1 industrial to C3 neighborhood mixed use, please signify by raising your hand for approval. Are there any objections? That's unanimous approval. Thank you. All right. The next issue we have in front of us is a road name change request in the Bluffton area, changing from Linden Plantation Road, Linden Plantation Drive East, and Linden Plantation Drive West to Linden Park Road, Linden Park Drive East, and Linden Park Drive West. Would you like to start with this one, Rob?
Yes, one of the things that the Planning Commission gets to do every now and then is consider a road name change. And one unique thing about this is that you're the deciders. This is not a recommendation, but you actually, get to vote up or down. This is a request that was,
Ooh, ouch.
yeah, I don't know, maybe I
feel
don't want
really
to make you
good.
power hungry. This is a request from one of the property owners, and if you notice, we didn't include the petition, but basically all the property owners signed a petition agreeing with this road name change. It's currently named Linden Plantation Roads, and then it splits to Linden Plantation Drive East and Linden Plantation Drive West. And the applicant, Lucy Crosswell, was requested, and I guess, from, agreement from all the family members, and there's also a letter that's attached to the staff report, that they would like to change the name to Linden Park Road, and they said that this is a historic name of this area, and they're interested in reflecting what was on mid-19th century maps for the area. And I provided a map showing each of the parcels that are affected, where the roads are. As far as staff is concerned, the considerations that we have, the first thing we look at is the list of, the petition. This one was unanimously signed by the property owners. So that was not a concern. We make sure that there's no duplicate names. That's something we work with E911. There's no duplicate names of Linden Park. It's not a name of an individual. That's something that is discouraged in our ordinance. We don't allow numbered or lettered names, and it has to be consistent with historical or physiographical features of the local area. So if they're choosing a name that is not consistent or historically consistent, doesn't mean that it has to be, but if it's something that's blatantly inconsistent with the history of the site, that's not permitted. And as far as those evaluation criteria, staff supports this road name change. And I forgot to mention where this is. This is in the Bluffton area, off of 46 as you're going west out of the old town of Bluffton. Let's see.
Is it one
It's
of the,
about a mile before you get to Buckwalter.
is it one of the donut holes or something along that road, or, because some of that bluff,
Yeah, that area is fairly consistently Beaufort County, but it's one giant donut hole. This part of it.
okay,
And
any questions, or is Ms. Croswell here?
okay, it doesn't look like she joined us. I think she was going to join us by Zoom. But,
Okay. Well, I see her letter and her rationale, and I see that she got the petition signed by great majority of the property owners. Are there questions? Okay, I have a motion to approve the road name change request in the Bluffton area from Linden Plantation Road, Linden Plantation Drive East, and Linden Plantation Drive West to Linden Park Road, Linden Park Drive East, and Linden Park Drive West.
I'll make the motion.
We have a motion.
I'll second.
We have a second. Any further discussion? All those in favor of the motion to approve the name change, please raise your hand. Okay, no objections. That's unanimous. Okay. All right. We come to item number 10 on the agenda, text amendment to the Community Development Code, Section 3160. Consolidate use table in Section 4.1.190 recreational facility campgrounds to revise the campground standards. Rob, you want to describe the background on this and
okay.
what's involved?
And this goes back in 2018, our staff, we initiated some changes to our campground standards to try to provide a little more, make it more, I guess, contextual to what part of the county it's in. Before it was a one size fits all, but they were modified to include 3 types of campgrounds: primitive, semi-developed, and developed. And the idea was that the impact of a small tent camping or small camper, campground in a rural area was going to be much less than a luxury RV park with hundreds of sites. And we wanted to make that distinction in the ordinance and make sure they were located appropriately in the county where they were consistent and compatible with surrounding land uses and also had the necessary infrastructure to support them. So we made those changes back in 2018. But we did notice some of the language needed cleaned up. There were a few things in there that were they were making it a little bit confusing in terms of which district, which types of campgrounds were allowed, because we had one thing in the use table and another thing in Article 4, and the way they were written, it could be interpreted 2 different ways. And so we wanted to make sure we cleaned up that language. So what we did was we modified the table, the consolidated use table in Article 3 to specifically call out the 3 campground types, make it clear which district they were permitted in. And we made sure that the language in Article 4, when we describe what the specific standards are for each campground, that they referred to that table and that they were consistent. And so we wanted to clean that up. There was some concern about, we had a maximum 14-day length of stay, but the concern was that somebody would just, exit the park, do a U-turn, come back in and do another, set of 14 days. And so we strengthened that language to say, 14 days, any 14 days within a 30-day period. That way, somebody is not doing 2 back-to-back stays. And some of the concerns there is just making sure that this didn't turn more into a permanent home site, that it is more, for people who are visiting the area, because it just doesn't have the services for somebody's permanent residence. We made what I believe is a necessary correction. in the old ordinance for primitive campgrounds, the buffer was 30 feet, but for the semi-developed and developed, it was 100. But if you're in a rural area, you want to make sure that you're well buffered from surrounding developments. And so we want to make sure that that was consistent with the other two. We wanted to clarify language about what types of campers or RVs were permitted in each one. The primitive campground is primarily restricted to tents and small campers. And so we went by, kind of industry language as far as which types of class vehicles are permitted. And that is pretty much it. Oh, the other thing, and this, we wanted to make sure that semi-developed and developed campgrounds had access to, tapped into public sewer and water, because you're talking about an impact that, having that many sites in a small area. We wanted to make sure that we were adequately addressing solid or wastewater and drinking water for those sites. But that's generally what we're proposing. If you remember last summer, this happened to come up, but it was, I would say, an unfortunately timed list of changes that were coming up is a pretty contentious campground that you all may be familiar with from our previous meeting. And so at that time, we had promised that we would have a workshop with the public in reviewing this at the staff level. None of these changes, I think that these changes are necessary regardless. If there are additional changes that want to be considered for campgrounds, we would be open to that, but we don't think it should slow these down. I think these are necessary to clean up the language so that the next campground, somebody applies for, that we have very clear language, that gives staff guidance on where it's permitted.
So let me just make sure I understand what you just said. If there are further inputs after this gets reviewed, there is a potential for potentially another set of amendments.
I mean,
You're open to that.
Yeah, there's always an opportunity for that.
Yeah.
But at the staff level, we felt these changes were necessary to clean up the language, make it much more easy to interpret at the staff level and predictable for somebody applying for a campground. The other thing I wanted to mention, Steve Andrews is here. I've been in touch with him about specific changes he would like to make, and I think you received a letter from him.
Right.
So you had asked me, I guess, after he speaks, if I'm willing to weigh in on that as well.
Okay. Questions of Rob?
Is there anything we can say that 24-hour security must be at these campsites? Because I think that's a lot of objections from, I would think, the neighbors that they're worried about that. And I was just wondering if there's something we can put in there that requires the people who own facilities to put in 24-hour security.
Yeah, and it's something that we could do. I was really leery about anything that was getting too operational in terms of telling people how to run their own business. There's that fine line between, somebody offering security on their site and, what is the role of local government in regulating campgrounds.
When we first talked, just to follow your question, when we first talked about these, initiate the ones that are currently on, have been approved, way back when, we brought up the issue of compliance. And how do we assure compliance? That's not something easily attained, but we ran into the same issue when we were looking at short-term rentals. And we instituted a permitting policy. Is it potentially possible to institute a permitting policy such that if there is a reported violation that is substantiated by the county, that the permit would be suspended for X number of days or fined, something which would demonstrate that it's important to the surrounding neighborhoods for compliance in this issue. I know we bypassed that last time. I think with the increase in the number of campsites that are in campgrounds that are beginning to occur, particularly over the last year or so, it would avail us to consider a permitting policy that would seek compliance and violations be either fined or suspended of their operation for a period of time. I don't want to get into the legality of that, but is there any reason why permitting would not be a viable solution?
Are you talking about permitting individual campers inside the
No,
campground?
permitting the owner of the site who,
Yeah.
the operations.
There is a permitting process.
Such that if there's a violation,
If there's a violation, we would send code enforcement out there to investigate it and write them a citation if they were in violation of the campground standard. And that would go before a magistrate. The magistrate would determine guilt, just like a police officer. If he catches someone speeding, he'll issue a citation and they have to go before a judge, and the judge will determine if that person is guilty of speeding or not and assess a fine. And the fines grow successively for each day the violation. I mean, the fines are each day that the violation exists constitutes a separate offense. So they could be fined daily.
would it be purposeful to reference that permitting provision for compliance of length of stay? We did it for short-term rentals, didn't we?
I'm not really sure how we referenced it, other than just to say that they have to receive approval from the county zoning board of appeals to have short-term rentals. And we would not advocate that we do that in this particular case, because sometimes campgrounds, it makes sense for them to exist. What we're having right now with regards to campgrounds are not a problem anywhere in this county that I know of. Nobody can point to a case where any campground is causing an issue. We're reacting to one of the things that I often say as a planning director, when I was planning director, now as a county administrator, 99.9% of the issues that we deal with at local level is a problem because somebody perceives it's going to be a problem. What we're dealing with the campground issue is a emotional argument to people that have no basis to make those arguments because they're reacting to something that they don't want to see happen to begin with. And people that are going to operate campgrounds, it's in their best interest to keep the campground clean and safe and operating appropriately so that everybody understands the standards. But should we have a situation where somebody's not doing that, we will do as we've done in the past with campground owners who violate the standards. We'll go out and write them citations and take them to court. We're in court right now with a campground that expanded illegally in the county, and we put them under notice of violation. They went to the zoning board of appeals. The zoning board of appeals denied their request for a buffer variance. They turned around and sued the zoning board of appeals. And now we've written them citations because they went out and expanded the campground again in violation of that. So, and we're working through all of that at this point. So that's the way you deal with that particular issue. There's a mechanism in place to deal with legitimate concerns and legitimate violations of the county codes and ordinances. And nobody has to state that they're going to comply. Banks, when you go open a checking account, they don't require you to sign a statement saying you're not going to overdraw your checking account. Sometimes people overdraw their checking account and they have to pay fees and penalties for doing that. So, we don't need to, in my mind, we don't need to get carried away in the enforcement on campgrounds, because campgrounds really aren't a problem.
So code enforcement, you believe, is adequate?
Yes.
The guidelines are adequate for permitting or abuse of permitting?
If we got a call saying, hey, this campground's allowing people to stay more than 14 days, we would walk in there and tell the people to crack their books and let us see how long these people actually rented a site. Because it's all documented. It's mostly documented online at this point. So, it's just like with mining, that we get, my dump trucks from a mine shouldn't be on the road at the same time school buses are on the road. There's been no documented case that I ever come across. I'm sure if you research somewhere in the United States of America, you can find a case where a dump truck hit a school bus at some point, but it's not because there was a mine, because dump trucks and freight trucks are on the road with school buses all the time. The fact that the mine's going in doesn't have anything to do with there being necessarily an increase of accidents with school buses. So, and I say that because that's the similar type of argument we hear with mining in opposition to mining, and you really can't tie the two together.
Gotcha.
People don't typically live in campgrounds unless, you know, unless it's in an area where a lot of construction's going on. So,
Well, as long as we've got you up here, and I certainly appreciate you taking the time on what is otherwise, I know, a very busy job. And this is either for either one of you, whoever feels it appropriate. The issue around density of per acre, number of campers or campsites on an acreage. Is this something, there is, I would assume, some differentiation depending on the type of campsite, whether it's a semi or fully or just a campsite. Is that something that is reviewed within the SRT provisions for density? Or are there general standards for limitation for number of, on an acreage basis? I think that's part of Mr. Andrews'
I'm gonna let Rob review
Okay.
that because I haven't looked at that ordinance in quite some time. But
Thank
I'll
you.
let him look at it.
Thank you, Art.
Yeah, it's mainly dictated by the type of campground. A primitive campground could only have so many sites. You know, a semi-developed campground, there's a minimum size for a campsite, and there's a maximum number of units that are allowed in that. So it's not dictated by density, but it's dictated by the size of campsites and then the overall limitations on the number of campsites.
Okay.
Just to follow up on Ed, Rob, that's the rationale that primitive sites can have on-site septic and on-site potable water, right? So they don't have to be hooked into the county sewer and water, right? I mean, primitive,
Yeah,
it doesn't require
it's a
that.
lower
It's because of
intensity
usage.
type
Right,
of use, and you're going to have smaller units.
right. So you've determined for primitive, that's okay, but for
Yes.
semi-developed and developed, I mean, from what I read, that's not, it's a little different from Mr. Andrews'
those-
letter, but that's the county's position. Got it.
Other questions? Okay. May I have a motion?
Well, I know we have somebody.
Oh,
from the
I'm
public.
sorry.
Yes,
Maybe
it was-
we want Mr. Andrews to speak up here about the exemption. Sorry, sir.
My name's Steve Andrews, and I appreciate y'all giving me a chance to come talk to y'all. The simple ask is that on the semi-developed and the developed campgrounds, that they're currently restricted to only existing with public water and sewer, and to ask that y'all would consider allowing those to be on-site septic and on-site potable water. So the reasoning behind that is they're specified, especially the semi-development, is T2. And in Article 6 of the ordinance, it speaks to not extending sewer into the T2 district unless there's an environmental need, but not for new development. So you have one section of the ordinance that says, don't bring sewer into T2, and now we have a campground that can only exist in T2 but must have public water and sewer. So in conversations with Rob, he expressed that one of the concerns was to get too much density that would overstress the infrastructure, primarily roads, and that's consistent with the comprehensive plan. So the compromise that I offered for consideration is that you would allow these campgrounds to be served by on-site water and sewer, but you would set restrictions on the size. So you would not be able to overload the infrastructure that existed. And then in the letter I wrote, since the discussion item was on whether you can or can't have public sewer or on-site sewer. Then I just looked at the sewer loading to try to get some recommendation for what the density would be. And that's what I went through, that the loading on a trailer or a campground is 120 gallons a day, and I don't want to get bogged down too much in the numbers. And for a single-family home, it's 120 gallons per bedroom. So I said, if you're in a rural area, smaller home, possibly 2 to 3 bedrooms. So the load on the infrastructure for a camper would be 2 to 3 times less. And so I made the recommendation that you could have, if you could have one house per 3 acres in rural, in the T2, then you could have 1.5 RVs per acre, or looking at it as units to the acre, it's 0.34 units for a single family house. It would be 0.68 for RVs. So that bogs down a little bit much in the numbers, but the simple ask is, I understand why it's written like it is. I think that's good policy to restrict the density, or make sure the infrastructure is there to support those units that can go up to 200 campsites. But if it's in T2, there's no water and sewer, that seems like a great place to have a campground, is in a rural area. So could you make an exception that you would allow semi-developed to have on-site water and sewer, but then control the maximum density? So if there's questions, hopefully that you can follow that.
Questions, Mr. Andrews? Rob, do you want to address? Thank you.
I think I'd like to have a chance to look at the request, and, there could be, some opportunity for flexibility, for low density sites. I just want to make sure that we as staff are able to kind of evaluate, making sure we're not, allowing development that's incompatible with rural areas. I think that, the idea of having RVs on a low density site, with a lot of land to support it and buffer it from other uses.
Yeah.
I don't necessarily object to that. It's something that we want to look at a little further.
Well,
So if
my response to that would be great. I mean, to take a look at it. That's what we're here for. So you would be asking us then this evening to consider the proposal that you've got with the potential for an amendment down the road after it has done a staff review. Do you want us to wait on the proposal here until you've had that review, or would you prefer, is there any problem with just doing the one part and then amending it later?
Couldn't we do a delay? Couldn't we do a delay?
Well, if the staff is asked to take a look at it.
Right, so if we delay the decision, that will give them,
Yeah, I mean, we could delay a decision on the whole package, or not.
Or could we also approve it with a recommendation to amend the Article 3 to include a low-density option for on-site sewer and water?
They ask for a review, but that doesn't make it.
Do an approval with conditionally and ask for
You can do whatever you all are comfortable with.
Yeah.
If you want to delay it, then we will look at it and give you a recommendation next month. If you want to make a motion with a condition attached to it that we consider an appropriate density, then that's fine as well. Whatever you all are comfortable with this evening. This is not time sensitive.
Okay, that was my question.
For us to move this forward at any time.
all right.
Yeah, I mean, we obviously want the ordinance to be just a little better, with these changes, but, I guess it would be either having us come back or a big, trusting staff to go in that direction and go forward to natural resources with changes that are consistent
So if we were to approve the basic proposal and then you decided to incorporate the exemption, that would go forward to natural resources, wouldn't come back to here. It would
Yeah,
be-
and it would take some trust on your part, you know?
Trust you.
Okay, so is this septic discussion, is that really in any way, in any conflict with any of the proposed changes that you were making here?
It would be, we would have to have an exception because we pretty clearly spell it out. You know, primitive campground could be on septic, semi-developed and developed have to be on public
Okay.
sewer.
So if we pass this then, and you somewhere down the line decide you want to make an exception, you'd simply have to write in an exception to this.
Well, it would have to go through a formal zoning
Process.
amendment process. I guess the question is, could it be bundled in with these changes, either something that we make prior to going to natural resources, or we come back to the August meeting with some revised language we could do, you know, to the planning commission.
Yeah.
I think that would be the two possible ways to do it.
I have a concern with septics, okay? And I lived in a septic in my house for 15 years, okay? And I was forced to learn a lot more about septic systems than I ever dreamed I would ever have to know. You have a little tiny problem with a septic, and it is not a little tiny problem. And that's with one family, with 4 people, with using one septic. When you start to talk about commercial business here, that's what my concern is. I would really question the business acumen of somebody who would recommend a septic system for a campground. I like, wow, did you really think this through?
You know, and there's different ways that it's handled on site. Sometimes the units have to, you know, dump their waste at a waste station that's regulated by DHEC. You know, so there's different ways that it's handled. And I think that's something that I would like to do at the staff level is talk to DHEC and look at what they typically permit on campgrounds and make sure we're not allowing something that's going to, you know, be an environmental overload to the site.
Yeah, exactly, and that's going to become an enforcement nightmare, and the owner of the development, he's going to have the problem now, and now he's going to have to invest a lot of money and decide if he has a problem with the septic, is he going to fix it, or well, the old rule is you can't repair a septic, so that means if you have one field and it's X amount of feet, then you have to have enough room to build a second field. That used to be the rule of thumb. I don't know if it still is. And I don't know. I think, 2021, right? I think they belong on a sewer. I think septic.
I tend to agree with you. The conditions, there are conditions in Beaufort County where septic inundates our soils and our environment, pollutes our waters and so on. And some of these campgrounds are in sensitive areas. I don't think we want to take a step back and look at an exemption that would allow septics to be on premise. That's just my gut feel, that's where I stand on it. So, is there any more discussion on this issue?
We have a couple online chats. There's a couple questions online. First is, are there existing campgrounds today that can be named as examples of each campground that the code applies to?
I'm sorry, can you speak up?
Are there existing campgrounds today that can be named as examples of each campground that the code applies to? Is the first question.
That on your screen, you can read it.
Well, no, this code only applies to new campgrounds, correct?
Yeah, but if we're looking at local examples, I would say, Hunting Island State Park is probably a semi-developed campground. It's not a full-blown, it's not like a mini resort. I would say that some of the RV parks on Hilton Head Island would probably be similar, or what we're currently permitting at Hilton Head National are the developed campground, where you have RVs, you have, amenities, restaurants, entertainment, things like that for the development. Primitive, exactly sure. Maybe tucked in the woods over on St. Helena. So I think we do have examples of these, and the idea is that, they're in areas that can, basically support them, the infrastructure, the surrounding land uses are compatible with that type of campground.
Okay, and there was a second
The
comment?
second question is it possible to allow a variance that would allow T2 to have access to the county sewer and water, rather than septic allow the sewer into T2?
Or currently our code discourages or does not allow extension of sewer into rural areas, except for if you're in a certain distance from an existing sewer line, or if there's a health safety issue. So we try to limit the extension of sewer in rural areas, primarily for the purpose of, not wanting to encourage development or intense development in those areas. And so, I think that this gets to the heart of what Mr. Andrews is requesting, is that if you do want to have an RV park in a rural area, there's a little bit of a catch-22, because we don't typically allow the extension of sewer in rural areas. There are some areas that have sewer, such as St. Helena, in the Corners community, and, but those areas are limited. And currently, the only case that we allow extension of sewer in rural areas is for, to take care of an existing health issue, or if somebody is already close to a line and they're just simply tapping in.
Okay.
We did leave in there that a semi-developed campground could be located in G2R if it does have access to community sewer, right?
Yes.
I'm sorry, would you repeat what was said there, Rob?
The semi-developed campground is allowed in T2 rural, but it's a stipulation is it has to be on an existing sewer line. So it has to be in one of those areas where we do have sewer in rural.
Gotcha. All right, so are there any other questions? If not, we have a couple of options on the motion. The motion would be to pass or not the proposal before us with a amendment that would allow staff to study the issue requested for an exemption by Mr. Andrews. That's one. We have another one that would be allow for these without that exemption, that would allow for the basic proposal without the exemption under study. Or we can, well, that's the options, with or without. Do I have a motion one way or?
We have a motion to, the potential of delaying.
Yeah, I move that we delay.
We can delay
I think that's
consideration
what I'm
until you
hearing
understand.
around the table.
Okay, all
but,
right, that's the third.
I actually agree with
That's the
Kevin.
cleanest way.
Okay,
We just need somebody to put that in the form of a motion.
Well,
I move that we delay this until next month to give staff time to.
I second it.
request.
okay.
A comment on that, my confusion, I very much agree with Kevin, and I think it's the policy of the county to take people off septic and get them on a county
Right.
water. This is a huge issue in the county. And by the way, there are people on, poor people on Hilton Head who are like being penalized because they haven't, and they need, help to get hooked up. So it seems sort of astounding to me that we would consider giving a business like free rein on this when other people are having to pay to get hooked up. So I have a problem with that. I also am confused about, we're talking about two metrics of measuring. That is, one is whether you should have on-site sewer and, septic and water. And then the other is, well, we'll solve that problem because we'll limit the number of people. Well, those are two different metrics of measuring what this development is going to look like. I don't see any alignment between those two. Like, either you limit the number, you let everybody have it on site, and the developer says, I promise to limit the numbers, or you say it's a county policy to get people off of, private to get them on sewer, on county water, and that's the trend of the future. So I mean, I would vote to delay because I see that the county is struggling with two, to me, quite incompatible ideas of how to measure success here.
Well, kind of goes back to, I don't know if y'all remember when we were talking about the size of neighborhood developments on or off of sewer. Do you remember when?
I don't, but
Okay, well,
I'm happy to remember.
Basically, your density, if you don't have sewer and water, your density goes way down, and well, your lot sizes go up. And it's the same idea. What Steve is saying is that at least you give somebody the opportunity to have, maybe a quarter as many
units
or
whatever,
campers
sites.
or whatever, but at least have the option to do it. Yeah, rather than it just not be available at all.
And with the low density, you're also increasing the chance that there's available land for a drainage field.
Right.
Well, then we're totally getting into site-specific. If it's near the
Well, but
marsh.
it's so heavily
If it's near the
regulated by
May River,
DHEC. DHEC regulates this above and beyond what we do. And
Yeah, I mean, I love, Rod, that you said you'd like to talk with DHEC. So if the motion on the table, Ed, refresh me, Carolyn, your motion, and Frank, if it's a delay so that Rob can talk with DHEC and talk with Mr. Andrews and others.
To research it.
Yeah, I that's something I could support. What do you guys think?
No, I think we should just vote for this as it is now. That's my own opinion.
I feel the same way. I wouldn't, it'd be hard pressed to change my concerns for septic fields in a campsite,
But then
regardless of the,
do we have a
Number of
motion
camps and
and a
campers.
second or not?
we did.
Rita, could you
yeah,
restate the motion?
I'm just talking
we-
about, I'm having a
Yeah.
discussion.
We have to vote on it and vote it down, and then we could have another one.
That's,
Or I
that's,
can
vote on the
modify, I
motion, or
can
you-
modify the motion.
you don't have to, you
No,
can
we
vote on that.
we can go up or down now.
It's up to you. I mean, you can withdraw your motion or you can modify it. Which would you prefer? Or go forward with it? Three options.
Will we just make a motion to deny the applicant's request?
No.
He doesn't have a request. No. He doesn't really have a request.
For the letter, I was referencing the letter.
I mean, the issue on the table are the staff initiated amendments.
That's
I think
correct.
the question is whether to approve them,
Right.
directing staff to look into that issue and then take it on to natural resources.
Right.
Or look into that issue, take it back to the planning commission, which would be deferring, or just move forward and let that be a staff or a citizen initiated amendment at some future date.
And then you asked, let me see my notes here, you asked to be able to review the request.
No, that's just.
Well, either way, if you want us to look at it, we want to have some time to kind of look
Right,
at the.
that's what I was basing my motion on, is your request to look at them.
The motion that you've made is fine.
Okay.
If you want to delay it to give Rob a chance to talk to DHEC about the possibility of what can be done in rural areas that do not have access to sewer, we're happy to do that. And if you can vote on that motion, if it doesn't succeed, then another motion will be in order.
Okay, let it roll then.
All right. Are there any further comments before we take a vote? All right. All those in favor of the motion made by Caroline for postponing a decision on the proposal made by the county for consideration of the amendment request made by Mr. Andrews to be investigated. All in favor of that motion, raise your hand. All right, all those opposed? Okay, so we have 3 against and 1, 2, 3, 4. The motion for further investigation passes.
So we'll be back in August.
All right. Good discussion, y'all.
Yeah, I mean, yeah.
Easy issues. All right. Next item. Text amendment to the Community Development Code, Article 5, Division 5, Section 5, general parking standards, off-site premises parking to provide additional flexibility for shared parking provisions. Rob?
Okay, well, this is an amendment to Article 5, Section 5.530B1, and it deals with a very specific issue having to do with off-site or off-premises parking. And this is an issue that we realized in application that our ordinance, we want to be able to provide flexibility. If somebody is, wants to have an arrangement with a neighboring property owner to provide overflow parking for a development, that flexibility is built into the code as long as both parties have some sort of agreement. When we started looking at how to execute this agreement, we realized that our ordinance was really specific, and it said that the parking arrangement would be a covenant that would run with the land, and that just seemed to be very restrictive, and it's something that very few people would be willing to do. It's almost like really kind of giving over a part of your property to somebody else to use for parking. And so we realized that the old ordinance, the ZDSO, had, I would say, more flexible language regarding this off-premise parking arrangement. And so that what we're recommending here is to kind of adopt what that old language is, that requires an agreement with a neighboring property owner, but doesn't require that covenant to go with the property once it's sold. The other thing is that in evaluating this, we also added, we made a provision that if they could provide access by valet or shuttle service, that there's an opportunity to go beyond the 600 feet that we allow in the shared parking arrangement. This is obviously something that staff would make sure that we had the documentation and assurance that they have those provisions. But if you see in the background report, we want to be able to be flexible because there's there's speculation that in the future parking demand may go down with the increase of use of Uber and Lyft and other services like that. And so we want to have that flexibility built into our parking ordinance to allow for these types of arrangements.
Questions?
No, sounds reasonable.
Agreed.
All right.
I'll make a motion.
Do public comment? Anything?
Do you have a question?
There's
I'll second
no
it.
online comments or anything?
No.
No?
Jason, did you make a motion?
I said I'll make a motion to accept the text amendment to the Community Development Code, Article 5, Division 5.5, Section 5.530.b.1, General Parking Standards. I'd make a motion to accept the change.
I'll second it.
All those in favor of the motion to accept? Opposed? Unanimous? Approved.
All right.
All right, let's go on to, are we ready for number 12, coastal resilience? This looks familiar.
So this might look familiar to y'all. This was something that we took up at our March meeting. These two ordinances, the coastal resilience overlay, and then the next one is the fill ordinance. And so these, just a real quick background, these both came out of the Ladies Island Plan as recommendations. And since that time, staff put together kind of a working group, a task force to look at both these issues, because we were kind of given, I would say these are pretty tall marching orders to consider these two ordinances. And since the county would be adopting them, we really have to look at the impacts across the county. And then if we're looking at just the unincorporated county, we wanted to make sure that we were working with the municipalities and with other people who are experts in the field. So we had developed two draft ordinances, but it became clear that we had not adequately worked with the local realtors, especially on the coastal resilience overlay, because that one especially is relying on disclosure to occur, when property is transferred. And so we've been working with the local boards of realtors since January. They did have some very specific comments that came to the Planning Commission at March. Those comments then followed to Natural Resources. And the chairman of Natural Resources, Alice Howard, requested that the staff kind of take a step back, meet with the realtors and the home builders to make sure that we're addressing their concerns or we're considering their concerns. So what you're looking at now are some revised ordinances. The one that has the greatest amount of change is the coastal resilience overlay. And if you remember from the last time this went before the Planning Commission, it's basically a requirement for disclosure when property is transferred. At the last meeting, we defined the areas that were the coastal resilience overlay would apply to is any area at or below 10 feet above mean sea level. You know, as with the NAVD 1988, there's one thing I've learned through this process is there's so many ways to define sea level, and so you have to really be specific with your datum. The problem with that, and so what we were running into and what we realized in our meetings with the boards of realtors is that there was a little bit of redundancy, and there was also, I think what we had was something that was going to be difficult to defend because we're simply picking a contour, and it's also mapping contours. We have really good, we have LiDAR today, and so our elevation contours are a lot more accurate today than they are on the old USGS maps. But it's still something that is subject to, it's something that puts the county in a defensive position when we're asked to defend, how'd you come up with this 10 feet and how do I trust these numbers on this map? And so what we propose to do, all at the same time that this is going on, there has been a very large change in the areas that are defined by FEMA as special flood hazard areas. We had maps in place for the last 30 years that defined certain areas as special flood hazard areas that required the purchase of FEMA flood insurance for homeowners. Those maps recently changed in March. The county had, finally the FEMA released the new maps, so the county adopted them. And they've changed significantly. The floodplain has actually gone down. The area that it applies to has shrunk, all at the same time that we are seeing more and more indication that we're looking at rising sea level. So we wanted this ordinance to direct to a certain group of home buyers. So currently, and we have the map on the screen, and I apologize, it's a little hard to read, but this is just a copy of 4 quadrants of our the FEMA flood maps. The area that is very dark gray, that includes the water and the marshes, that's zone AE, and that is the area defined by FEMA as the special flood hazard area. If you're in those areas, you have to buy flood insurance. You also have to make sure that your house is built at base flood elevation plus freeboard. There's also an area called Zone X shaded. It's the lighter gray on these maps. And that is the area defined by FEMA as, the old language would have said 500-year floodplain. The new way of saying it is that there is a 0.2%.
0.2%,
yeah. Annual risk of inundation on these properties. And the idea was, with the coastal resilience overlay, we believe that it is these property owners who really need to be notified that they're not in the floodplain, they're not required to buy flood insurance, they don't have that disclosure that is, spelling that out when they're buying property. And because our maps changed recently, it very easily could be somebody coming from another part of the country not realizing that a lot of these areas were in the old floodplain, that they could be, they're not out of the woods as far as being subject to flooding. And just having simple language notifying them that, you're not required to get FEMA insurance. However, property owners still have the option to get flood coverage in their private insurance. It's much cheaper and it's recommended, especially if you're in these areas. This is, meant to provide that information to a property owner. Some of the things we looked at is there is general notification for flood risk, but it's rather vague unless you're in in the dark gray, in the special flood hazard area. And also FEMA is very much in favor of, they're not concerned with redundancy. The redundancy is good as far as if it's getting the message out about flooding risks. There's also concern that these new maps, there's a lot more work that went into defining these areas. They're a lot easier to use. It's much easier to see whether you're in or out of the floodplain. They have parcel boundaries. But the concern is that these studies that these maps are based on go up to 2016. And since that time, we have had some major storm activity, flooding activity that's occurred in the county, which point to that these maps in the future may not adequately represent the risk. And so we feel that this provides some notification to property owners that, there still may be risks, and it's just encouraging people to act accordingly. And we are working with the other local jurisdictions, City of Beaufort, Town of Port Royal. Town of Hilton Head Island is following very closely with what we're doing, and they're very interested. I know their staff is, they're obviously, that's something that they're going to have to work to bring forward. And so I just wanted to give you that background. So basically those areas in the gray, this is Ladies Island. This particular portion of Ladies Island is low in elevation, so it kind of gives you an idea of what areas are in the floodplain, what areas are in the Zone X shaded, which this ordinance would apply to, and then the white areas are those areas that are outside.
Okay, so the shaded area that you're referring to, the .2, are the light gray on this?
Yes, yeah. So it's called, there's no better term, Zone X shaded, or area of 0.2% annual flood, inundation.
So this is basically a notification process. It doesn't necessarily change anybody's behavior about building in a floodplain area, even if it's only 500.
No, and it wouldn't require, it wouldn't even require them to build a base flood elevation, because when you're not in a special flood hazard area, our requirements for where you build your first habitable floor are not dictated. They're only within the special flood hazard areas. It is purely a notification.
My point of view is that it moves us in a better direction than doing nothing with it. My concern is the accuracy of the maps. Mm-hmm. And your point made here about 2016, since then we've had Matthew and Michael, occasional tornado thrown in. How often will these maps be updated? Can we in fact initiate a procedure for updating them? I know if you have certain compliance factors, you can get a reduction in your FEMA rates. Is there anything that we could do if we were to specify greater areas, for example, where soil was an issue and drainage was an issue?
These are steps that we could take, and I know that the City of Beaufort, they actually chose across the city they chose a base flood elevation that would apply to all developments. The county did not do that, but all of those, so the thing that is, I would say, that is least in our control are the FEMA maps. They are what they are, and one of the good things about referring to these maps is that they are something that is backed up by the federal government. These areas are not something that the county is defining. It's something that's already been defined. It came out of a study. The county's options in the future, if we feel that these are not adequately addressing flood prevention, we could require additional freeboards, where the elevation for new development is higher. These are all steps that we could take in the future. As far as when maps will ever be updated again, we waited a long time for these, so I'm not holding my breath, but, you know, but there are things that local government could do if we feel that this is not adequately, you know, protecting us. And so this is kind of one step that, you know, we feel as far as notification.
Okay, any questions of Rob?
I have questions. It looks like they don't have to sign anything or admit anything until closing, where they put it in writing at closing.
Yeah, and that's actually a good point. And this is something that a change in getting this to you, I forgot to add that was a major concern with the realtors, is that is not at the point where you want to bring this information forward. And so as far as what I would like to change to is prior to closing, and then allow, you know, the realtors to decide when, you know, at what point in the process.
I would like to make a point because I bought a waterfront house, and the question I asked the people in front of the realtor was, did the house ever flood out? And the people said no. I moved in on a Saturday, was going to close on Tuesday, and on Monday the house flooded out. And had those people told me that the house had flooded out once before, I would have not bought that piece of property. All right, so that's why I think the real estates must tell the people that they are in some sort of floodplain before, when they enter the real estate office, if they're going to look at any type of property that's near water.
I would endorse that. You go to a I've been to many closings, and you go to a closing and you're inundated with documents to sign. Everybody is a party to that closure. And, you know, it's just like you sign your name here, sign your name, and the attorney says, I'm signing your name. I mean, have you had a chance to really understand what you're signing? In this case, property, it could be a flood area. So I would think that somehow we would specify in our direction at what point in time it would be best to notify. I mean, saying before closing, I mean, it could just be before you sit down, here, sign this document. You know, there's some upfront disclosure.
You might never even get to the point of closing if you found out ahead of time that, you know.
I don't know, but somebody wants to buy a house anywhere near the water. I certainly hope that they would look at these things long before they even walk in a real estate agent's office. I mean, to throw this into the mix and for the government to kind of to jump in and inject themselves into this, I don't know. I got a problem with it, especially, you know, the maps. Who knows if the maps are right, if the data is right? I mean, don't people normally, you're going to buy a piece of property, have some kind of an inspection done, you know, and you go through some due diligence steps yourself.
What would you ask the people and ask them if it flooded out and they tell you no? And the real estate is there, I'm not supposed to take them at their word?
I wouldn't ask them because they're never going to tell you that it flooded. Who would tell you that a house flooded? I mean,
well, that's the point we're making here. We want the real estate to tell the people when they come in that there's a chance that the house will flood out.
Well, there's a chance any house will flood out. I mean,
right.
I'm just saying that if I want to know if a house flooded out, I will go do my research and I'll find out if that house ever flooded out. You can hire an inspector and you can find flood damage. I've had houses that flood.
I don't know that
you can't hide it.
This is not really related.
Future risks. This is not looking at past flooding. I mean, that's something
no,
that
I
has to be
understand what you
disclosed
mean.
anyway.
Which is even more ambiguous is you know, I don't know. I just don't think that county belongs there. But
This really all this does is if somebody is not familiar with this area, it gives them an opportunity to say, hey, just so you know, this property is pretty low compared to other pieces that you might find. So it's not really I don't think it says.
And that's all I'm asking.
It's like the AQs.
Yeah, I think, a buyer beware policy is not something that I would endorse just go find out on your own. I would like somebody to give me, particularly, coming to this area, people come from all over the country, and they come because of the beautiful scenery and the water and so on. But do they examine the issue of flooding, other than the fact that they've got to get flood insurance? What does that mean? Am I in, I just happen to be in zone B, C, D, or whatever, right? I think the local government owes them some sort of a declaration that you've been properly notified. It's your decision how you proceed. We're not going to make you do one thing or another.
Ed, see, my point is that I see a lot of county overreach here. What you just said is where I would end it. Here are the maps. You've been notified. I don't think that the county should get in the business of telling people that there are, lower cost flood insurance policies available to you. I just think that is, that kind of reassurance, I think, could be interpreted as a remedy. That the county is saying, we offered you a remedy. In my opinion, the county should not be in the business of advising people or telling people that there are lower cost options out there. I think absolutely they should, have the maps. Absolutely, if you want it at closing or pre-closing, I think that's fine. But I would really trim down the language, suggesting that the county should tell people while they're looking or beforehand that the land was low. I just think the county's opening itself up to a lot of confidence that a buyer might have said, or a potential buyer, like, oh, county, they said there is insurance available. Like, why is the county in the business of telling people that there's flood insurance available? Really? That's just not.
I think the issue
County, I'm
was
asking
more
for the real estate to.
No, but I mean, my larger point, what Ed made. So I completely agree, except that I think the language should be trimmed so that it should end where here are the maps. The maps are going to change. We're never going to get, it's taken 30 years or whatever, right, to get these maps. I mean, my insurance just changed. For all these years, because I have a mortgage, I've had to pay all this insurance. Never flooding, I've never, since 1969, have never had an issue with flooding on our property. Come to find out, they say, oh, flooding is not your issue. I've been paying all this money all these years, right? So I know it changes. The county is never going to get on top of that. So why put yourself in the position outside of absolute providing the maps, showing people how to read the maps, having the realtors say, this is what the property, how it's indicated and defined on the map, agree with all of it. I just don't think the county should go beyond that.
Let me be clear, just so I didn't mislead you on this. I believe the realtor estate agents in this case have a responsibility to identify for the people the fact that they've been sold a piece of property that has a potential for flooding, and they've signed that they've seen that. I can tell you when I came down here, I had to sign a bunch of documents that acknowledged that I had read the documents and that I was okay with that, So I made sure I read every document.
Yeah.
And understood its consequence. And I think we owe our citizenry of that response, that activity, that involvement. I am not in favor of just letting them go out on their own at this point. I think moving forward, it moves us in the direction that we want to go. And that is, with the sea level rise and climate change, we're getting to more and more sensitive pieces of our land. It's coming in further. It's coming up higher. I was part of a military resistance review panel this morning where that came in discussion significantly. They are concerned and what potential for its impact on the military installations, etc. So I'm not against this. I just think I'd like to see it have a little more teeth, but I can understand the simplicity of doing it and just the notification. And that's all we're accomplishing. Notification doesn't change anybody's behavior necessarily. So we need to have unless there's more
I
discussion.
think we had at least two people from the public.
Oh, I'm
comment.
sorry, go ahead. Yes, ma'am, would you like to come on up?
Good evening, Chairman Pappas and members of the Planning Commission. My name is Janet Gresham, and I'm the CEO of the Beaufort Jasper County Realtors. I'm here speaking on behalf of the 1,900-plus members of the Hilton Head Area Realtors and the Beaufort Jasper County Realtors. As Realtors, one of our missions is to advocate for private property rights, and that's what I'm here to do this evening. We are opposed to the text amendment to Section 3.4.90 of the Community Development Code, adding the Coastal Resilience Overlay Zone and requiring real estate disclosure at the time of closing. In the interest of time, I'll share just a few of our issues. The stated purpose of this disclosure is to, quote, assist individuals in making decisions that involve investments that will last 30 years in light of projected coastal flooding conditions in that time frame, close quote. Disclosing this at the closing table does not meet the stated purpose. And this is the important part that you've all touched on tonight. Under the South Carolina Residential Property Condition Disclosures Act, Section 27-50-10 of the South Carolina Code of Laws, sellers are required to complete a residential property condition disclosure, which among other things puts the buyer on notice of flood hazards, wetlands, or flood hazard designations affecting the property, whether there is current flood policy in place, and whether there have been any FEMA claims filed on the property, and if so, the dates of those claims. And that section has been added within the last few years. The buyer is given this disclosure prior to signing a contract to purchase the property. That's the time when you disclose this information. So we are already doing that, and that's by South Carolina law. The CRO disclosure is unnecessary and redundant to existing standard practice real estate disclosures and may be susceptible to claims that its disclosure requirements are preempted by the South Carolina Residential Property Condition Disclosure Act. Additionally, I'd like to point out a couple of inaccurate statements under the section titled Purpose on your document there. The second paragraph implies that anyone buying property in a special flood hazard area is required to purchase flood insurance. But if a buyer pays cash, the decision to purchase flood insurance is at their discretion, just as it is with buyers in Zone X. The language also implies that the residential property condition disclosure is not required if the property is in Zone X, but that is not accurate. The residential property condition disclosure is required regardless of the flood zone, as that disclosure describes condition of the entire property, not just the flood zone. Our state contracts also advise buyers to seek the services of professionals to determine flood zones, elevations, wetlands, beachfront, and the availability and cost of insurance to include flood insurance. Per Dan Morgan of the Beaufort County GIS Department, approximately 67,800 properties in Beaufort County are located in Zone X and would be impacted by this ordinance. The federal government has determined that properties in Zone X are not in a special flood hazard area and have less than a 0.2% risk of flooding. Beaufort County and the municipalities recently approved these new maps. Requiring such a disclosure is contradictory and will confuse buyers, not educate them. As a point of reference, the Bluff Farm subdivision on Ladies Island is in Zone X and has an average elevation of 20 feet. But yet this disclosure would apply to that property and says it's subject, that property would be subject to sea level rise at a 20-foot elevation. Requiring the disclosure to be filed with the deed also makes it a permanent part of public record and places an encumbrance on the title. Could this potentially impact future transfers of the property? This ordinance will have many unintended consequences, and we respectfully ask the Planning Commission not to move this ordinance forward to the Natural Resources Committee. Thank you for allowing me to address you this evening, and I hope you will take my comments into consideration.
Thank you, thank you.
I have a question for you. That disclosure form, will you hand that to the people as soon as they come in?
That disclosure form is a requirement to be signed by every seller and buyer signs it acknowledging.
So if I came into an office, one of the real estate offices today, and I wanted to look at X property, you would show me that disclosure?
That disclosure should be provided to you at the time of, that you're interested in a piece of property.
You're saying should, but you're saying it also might not be shown.
It might not. There's no doubt about that.
What I'm
But you're
asking
also
is that
assuming-
it will be shown.
You're also assuming that there's a real estate agent involved in every transaction, and that's not the case. There are plenty of transactions where buyers and sellers are not represented by real estate agents.
Well,
So the disclosure that you're talking about would not be on the back of the real estate industry per se. It would be on the back of the homeowner to do. The disclosure also states in there that, you've got to have, landlords would have to put it in their contracts or their leases. How are you going to notify landlords that this is a requirement? How is this going to be enforced? What mechanisms are going to be used to educate property owners and landlords that they've got to do this? There's just a lot of problems with this ordinance, and we would ask that you not move it forward. Yes, ma'am.
Could you please explain why you think that having this document would be an encumbrance on the deed that would, quote unquote, run with the deed? Because I don't see it that way.
It's a public record.
Yep.
So when you, when a title abstractor goes to examine title to a property, this document would be recorded with the deed. So it's going to be shown as part of the deed, which in and of itself is a problem, because what if the zone changes? You've signed this document, attached it to the deed, and says this property is in zone X. So zone could change down the road.
Sure, but that's not a plus or a minus. I mean, the county is not, or, that's going to change. Lots of things change in deeds,
But if
right?
you're making it permanent public record, is my point.
And that's what you call encumbrance. See, I don't see that as an encumbrance or prejudice.
Let me explain it a little bit further. You put that on a title abstract, okay? The title abstract then goes to the closing attorney. The closing attorney sees that and could, not saying they necessarily would, but they could show it as an exception on a title insurance binder. That becomes an encumbrance. And by putting that as an exception on the title insurance binder, it goes to the lender for approval. A lender whose underwriter may be in the state of Kansas sees that on a title insurance binder and says, oh my gosh, this property is subject to intense storms and king tides and sea level rise. So now they're going to require that buyer to purchase flood insurance. Okay, so now you've got a property that the FEMA says, federally insured mortgages say you don't have to buy flood insurance. But now this lender can say, oh, we're going to require it. So now this $600 flood insurance premium may put that buyer out of approval rating to get that loan. So yes, it's an encumbrance.
I guess, I mean, I know I'm the one who just said that the county shouldn't be in this business, but I actually think that's part of market. That the market will determine that, and that's up for a seller to decide. And that, to argue the point that this is useful, I would like it to be more limited, but useful, then that's up to the market.
We're just saying we're already doing this, and this is just another step that is not necessary. And as we indicated, it could be considered to be preemptive of the South Carolina State Residential Properties Disclosure Act. So,
Ma'am, does that document cover all problems, like, for example, termites or mold or So in other words, the South Carolina law already protects, if you will,
Notifies.
or forces, doesn't protect because people lie, as Dr. House always said. But it forces the seller to put their John Hancock and say, these things are all, et cetera, and then sign them.
Yes.
And, you know, you have to take them at their word, and that's the document that the seller is gonna see. So they're not only gonna see the flooding piece of it, they're gonna see everything else. Then I don't know all the items on there, but
I
I'm
mean,
thinking
there
termites.
are,
Probably 20 items on there.
25 items on this
Yeah.
disclosure statement.
Yeah.
And it covers all conditions of the property. It also addresses soil erosion, drainage and soil stability, underground problems affecting the property, and then just the other zoning issues and things like that as well. Like I said, the seller is required to provide this under state law. The buyer signs it, acknowledging that they've received it. And, you know, you should ask these questions and do your
Yeah,
research.
absolutely.
Like I said, our contracts also provide and suggest to buyers that they seek professionals to do their research on the property.
Thank you.
Yeah.
Thank you.
Rob, what's the purpose of having it run with the deed? Just, I'm not trying to run her off, I was just.
I mean, this is similar to what we require for the ACUs, you know, when somebody's in one of the noise zones.
Yes, sir.
So it's very similar language. And it's basically stating something that already exists. I mean, it's in the zone X shaded.
But in terms of it being recorded with the deed, I could very much see where that could be problematic, especially with the banking aspect of it. But what benefits, why record it with the deed? I've never picked up on this before.
Libby, do you have a good answer for this one?
Well, I think, again, so it would be readily available. I mean, again, maybe the first time the research is done, if people aren't familiar with the Fema Maps, but as was mentioned, when the title research is being done, which I would say frequently is, then it would be right there in the public record. You don't need to go.
Yeah, that's a little concerning, just because, like what you said, you know, people reading it out of context as well, you know, in the banking industry. I mean, I could see where that, like Bluff Farms is a good example of being in that X.
And there are two zone X's. The white area on this map is zone X. The one this applies to is zone X shaded. And the contour pretty much follows, and I'll have to double check, but it's around 12 feet. So I need to check Bluff Farms and see where that line is. I mean, it's not meant to apply to places that are 22 feet above sea level. It's meant to apply to places that are basically just out of
That's even more arbitrary.
Well, can I ask?
It's on the map.
What's your name again? I'm sorry. Janet. My other question that I wanted to ask you was, you know, if this was introduced to the client at some point, when would y'all see that it would be appropriate? At the same time before the contract is signed?
There's no need in doing it, that's our point, because we are already doing it in the disclosure that is required by South Carolina law.
No, I understand that, but.
It's not needed.
And I completely understand that at closing is probably problematic. But if it were a one-page form that you were doing with your contract prior, I mean, would that be less objectionable to y'all, or?
Again, I go back to the fact that not every real estate transaction has a realtor involved.
I understand that, and you're right. But most people that don't have a realtor have better knowledge of what they're buying. Really?
You have a lot of faith.
That's the old
There
days.
are lots of people out there that think buying and selling property is very easy.
Sure.
They can do it on their own, so.
All right,
I believe we have one other public comment too. I just didn't want to get.
we have a public comment, yes? Did you want to have, I don't want to cut you off here.
No, it's fine.
Just back to Jason's point, though, I think he's right. First of all, I think this whole thing is way overreach. It's overkill. It's redundancy. And here, Jason sells me the house. So Jason fills out the form and everything else. And we close on the house. So now that the form that he fills out gets carried over on my deed. Now I go to sell the house to Carolyn, right? And now I have to fill out the form. That thing is gonna show up on her title search, right? When she does the title search, that's gonna show up, all right? And I'm saying, I mean, I'm against it to begin with. I don't think we should even be doing this. But to record the deed makes absolutely no sense because Jason had to do it when he sold me the house. I have to do it when I sell Carolyn the house. But the problem that's gonna happen is that Carolyn's does the title search and this thing is gonna show up. And now she's gonna have the problem with her bank or her mortgage. And we've created a problem with that wouldn't have existed, that there's no reason that it had to be created. Because I have to create the same form that Jason did and present it. So just the way it's written, it's like over redundant, overkill, overreach. This is like the nanny state. I mean, this is, I think this is way too much. It's already, especially if this wasn't being done, and I knew there was some kind of a form, and I'm glad Janet educated us on it, that now 28 items, I think, all right.
Well, I mean, I agree with
I will just say that, as I said earlier, the community rating system, they like redundancy. Getting the message out is important. The flood information on that form, that disclosure form, is very general. Doesn't tell you what your flood risk is. There's the risk that you would have in the special flood hazard areas where you have to buy FEMA insurance. And there's this area that has a different type of risk. It's not as great, but it's still there. And the message that we want to get across is just because you're not in the area that FEMA defines as special flood hazard area, that does not mean that there are not risks. And we believe that that is valuable information to the property owner.
Yeah, and I agree.
This is, the CRS system, this type of outreach, getting the message out in different ways is something that is important, because.
I mean, I 100% agree with you in that respect. I'm not sure that it should travel with the deed. I have an issue with that. And the timing in terms of when this happens, I think should be more flexible. I think you should let the seller and the buyer, obviously sometime before closing, but not necessarily at the closing date, because that could cause some problems. And I mean, I fully support it, other than I think we should be a little bit more flexible with the timing. And I really don't feel like it should travel with the deed, because that, I mean, I just think that could cause problems, unintended.
All right, can we allow the next public speaker to come up?
Yes.
I think we've discussed the pros and cons of this back and forth.
Thank you, guys. I am, or commissioners, I am Juliana Smith. I am the South Coast Project Manager for the Coastal Conservation League, and I'm here tonight to support the intent of this ordinance, which is an educational tool to let people know the risks of where they live. And you all talked about this earlier during the rezoning discussion. I believe Chairman Pappas, you said, and I quote, "It's important for people to understand the circumstances that exist before," now this, I'm adding this context, "before moving to that area." You all were very concerned about the neighboring property that the woman was looking at next to where she needed that rezoning. So I just want to put that out there. This is what this aims to achieve, to make sure people understand where they're going to. Yes, yes, there are already things in the process that try to achieve this as well. And yes, you could call it redundant, but as Rob said, for the community service rating, redundancy is important. This message needs to be out there as frequently as possible. Just this past year, the Island Packet had a front page article about how Beaufort County is at the highest risk of cumulative impacts of climate change than any other county in the United States. We shouldn't just ignore that. Now, it's not stopping people from moving here, right? We got lots and lots of new neighbors last year, but we do want to make sure that they are empowered and well-educated and better informed so that they can make the right decisions with the properties that they are pursuing. It'll help them be better adapted to the impacts of climate change if they know what's coming, if they know what's anticipated. I also wanted to talk about how just in these past 6 weeks, we've experienced 2 tropical storms. It's a pretty unusual frequency in the first 6 weeks of a hurricane. It's evidence that things are changing. Flooding is going to get worse, and it's important that we act sooner rather than later. Delaying preparations is never a smart choice. And this is a very simple disclosure that encourages folks to take action and be aware. So it's really, really the least that we can do. And I just want to make sure that I have all of the points before I walk away. One of the things that I wanted to say to your point is that, you know, maybe some of this information isn't coming through because the seller might not reveal it, right? I think that was mentioned up here. This takes it out of the hands of the seller being honest and upfront about the conditions on the ground because it's relying on a map based in science. So your shaded zone X is what's going to trigger this disclosure, not the seller, not the seller's experience, not anybody's necessary desires. Or feelings rather, this is the fact. The fact is it's in an area that's at risk and that people need to know about it. And so I just will leave us with that. And I hope that you all consider adoption. And I would say because redundancy is important, that maybe you might even consider extending this or expanding this into the special flood hazard area as well, the AE, the lower zone, 100-year floodplain.
Thank you, Juliana.
Welcome.
I know y'all worked hard, but can I ask you a question?
Sure.
Clarifying question? Or are we debating?
Well, I mean, I don't have to ask the question if you don't want me to ask the
No,
question. But I just have a question.
You have a right to ask clarifying questions.
Yeah, I'm asking her a question of whether or not you think that it being carried with the deed is important.
Yeah, I think that for me, it's for the league that it's not 100% necessary. It has to go along with the deed. I could see how it could be helpful for people who are doing their research. But if this is going to be presented regardless, I could see how it doesn't necessarily need to be there.
How about the timing? I mean, as long as it's presented at some point before the closing, is that?
I definitely agree.
I'm just trying to make this work for everybody.
Oh, no, I totally understand. And I definitely agree that at closing, I just went through the process myself. You are presented with a stack of papers. Someone does guide you through those papers, but by the time you're done with it and you're popping the bottle of champagne, do you really remember what you just went through other than the fact you've got your new house? I think it would be important to happen earlier in the process if possible. It would be nice to know what the best timing is. In my mind, as a person who recently went through that process, you would probably want to know this or be presented with this maybe before going into the offering stage, because
I would think so.
I would think so as well.
That's what they do. Before the person goes and visits the house, they get to see that 28-point checklist.
Yes, you're
Right?
exactly
It's like
right.
when you go look at a used car now.
I
They give you
did
the
see that.
Carfax before you look at the car. You don't want to fall in love with the house and then somebody hand you this piece of paper. You're not going to read it. You already fell in love with it.
Right.
You're going to buy it. You use the word risk. I don't see risk anywhere in here in this law. I see this is an area of moderate flood hazard encompassing the land between the special flood hazard area and the 0.2% annual chance or 500-year flood, and it goes on and on and on. So, I mean, I don't know.
Sure. And to that point as well, you know, this information being presented at that time when you're seeing the house, when you have this lower zone, because I had to request this every time I looked at a house. What elevation am I at? What is this property at? And at first, those were things that I had to look up myself. Now, not everybody's going to do that. I work for the Coastal Conservation League. Flooding is one of the first things on our minds. And so we should be a good neighbor and make sure we're letting new folks who are arriving, who are changing properties, know what they're getting into. So that is my feeling on that, the league's feeling on that.
And I agree with you, and it sounds like they're already doing it.
Yes, and redundancy is important in order to bring down those insurance rate for the community service rating system.
Thank you, Juliana.
I have a comment and a question for Kevin. Kevin, if you went to, called up a real estate and asked them to, this is what you're looking for, and you went into the real estate and they said, well, I have 3 properties for you. One of them is in a possible flood zone. Would you still go look at that property?
I might, depends what you mean by a possible flood zone, all right?
That's what we're talking
And I wouldn't
about.
call myself the average consumer. Would I put a real estate agent through? Would I put a car dealer through? Most people don't deserve, okay? Osama bin Laden didn't deserve what I put these people through.
But that's,
So, we're all different, like the lady said, she's worked for the Conservation League. The first thing I looked at when I bought my house in Bluffton was the elevation. And we're 37 feet above sea level. So I'm different than the average person, so I wouldn't be fair, wouldn't be a fair comparison. I'm not saying I'm better, I'm different.
I looked at the floodplain too, all right? And I'm not in the floodplain, but I still bought flood insurance.
Can I just say something? All of Beaufort County is in flood zone. It's an entire flood zone, there's just different levels of flood zone. And we're all in a floodplain. So, and everybody has the ability to buy flood insurance, no matter what flood zone you're in. And it is incumbent upon a buyer to seek out their professionals to get recommendations from those professionals as to what zone they're in, what elevation they're in. But, I can't believe an insurance agent wouldn't try to sell a flood insurance policy to a purchaser coming into this area.
All right, thank you. All right, we're at the point of consideration here where a discussion amongst ourselves is appropriate, unless you feel you need more information from any of the public speakers. The only comment I would offer at this point to the commissioners is, for me, there's a difference between setting a policy and how that policy gets administered. Because it's the administration of it that's important. And I think in any consideration in the administration of it or how it's carried forward would seek to eliminate any harm or potential harm that might come to the party who is getting this information. This idea of carrying forward with the deed bothers me a little bit. Or any other harm. I mean, we're looking here to perform a public good and a public notification and a public awareness. May not change anything, but we're attempting to do that, and that's moving us in the right direction. I would hope whatever we do in administration of this doesn't put a penalty on the party who's getting the information because it's going to follow them in perpetuity. And that's my only sensitivity to this on that, approving this.
My sensitivity to approving this, and I don't agree with it, and I'll state that up front for full disclosure, but even if I did, it's worthless. To present this document at a closing, it's worthless. How many people are actually gonna sit at a closing with their dream house, their lifelong dream, and actually gonna change their mind? I hate to say it, but unless, and the free market has told us how this has to be done, is the disclosure has to be when you go look at the house, not 8 weeks later after you've gone through contracts and inspections and lawyers and title searches and closings, and all of a sudden you stand there, oh, by the way, you gotta sign this here. You realize you're in a 2% moderate hazard zone here, and how many people are not gonna, it's worthless. It's worthless. It's not even a paper tiger at that point. And we say redundancy is good. This is not redundancy. This is insanity. It's not redundancy. So enough said. I've said far too much on this.
All right, any other comments before we take a motion?
Well, yes, I support this document going forward, but I don't think it should carry with the deed, and I don't think that we should state that it should be signed at closing. I think it should be able to be presented at any time before closing.
I think it should be when they're showing the property.
Yeah.
Yeah, well, that could be up to the seller, but at some point before.
Would you care to make a motion?
When should it be?
When they show.
I just have a question before,
Make a motion.
Jason. I mean, I feel so much consensus here. But what I don't understand is, as it's written, it has to go with the deed. I mean, that's sort of our issue. I mean, I think that lots of people feel like that's unfair, and I've been persuaded. I mean, I understand that. What I tried to get at, what is encumbrance? What did Janet mean by encumbrance? But Rob, is there any way to affect the good part of what you have described here without what I would call a negative consequence, or many others, of it running with the deed, running with the property?
That's something that we're willing to look into, because I talked to Libby, and that language came from the ACU's ordinance, which made sense, and that was, we worked carefully with the air station on that one. I don't know that it's necessary for this district, and so that's something that we're willing to look into, because I think that the importance is getting that point across when property is sold. It's not something that the properties, regardless, is going to be, if the county adopts this district, it's going to be in that district, and so the important part to us is the disclosure. So we're willing to look into that, and I think that that's something that we can change in this language, if that's a sticking point. And I agree also with the timing.
Yeah.
Y'all okay with maybe us looking at that in August with the other item, is there a time?
Is it time sensitive?
I don't know that it's, if we're able to modify this, if that's a condition of your approval, we're willing to look into making those changes, because we suspect that same issue will come up when it goes to natural resources.
Well, I can do that. I can make a motion if you would like me to.
Sure.
I just like
Go ahead. Sorry, Frank.
Would you put that when the property is being shown as the time span?
I think, though, we're going to look into what the best language, we don't want to be so specific, but, the simplest thing would be prior to closing, but, point is, do we want to dictate when in the process? Do we allow that up to the realtor? That's another thing that we're going to do some research on, but we'll try to pick the best language.
I don't know. The goal here is to prevent it from going with the deed.
Well, that, and also preventing it from being something that is passed on to the buyer at the moment that the property is being transferred.
The way I look at it is, some people will fall in love with the house, and if they've gone so far with it, and then if it's 30 days later they're told this, they might still go ahead and buy it and ignore what they've been told. That's why I'm saying it's the sooner the better, that the buyer knows.
Okay. All right, do you want to make your motion, or do we have another? Go ahead.
I make a motion that we recommend this for approval conditionally, conditions being that it not move forward with the
Natural resources.
with the deed, and also that it be presented at any time before closing at the discretion of the seller.
I have a second for that? Do I have a second?
A second.
All right, Jimmy seconds it. All right. All those in favor of the motion as stated, please raise your hand. 1, 2, 3, 4, 5. Opposed? Unopposed? 1, 2, 3, 4, 5, 6, 4, 1 opposed. Thank you. Thank you. Good discussion.
Great discussion.
One final item, and I'm hoping that this will go a little quicker. This was the second ordinance that was presented in March. We made some changes to it that we felt it was necessary to bring back to the Planning Commission. And this is the ordinance that limits fill in low-lying areas. The major changes that we made to this ordinance, and I'm willing to go into as much detail as you need with questions, but I'll right now focus on the changes that were made since you looked at this in March. The first one is the area that this applies to, when you looked at it back in March, was similar to the coastal resilience overlay that it was defined by 10 feet above sea level or lower. And what we're recommending is that this coincide with the zone AE on the Fema maps. Once again, we feel a lot more comfortable tying it into a map that has the backing of a study versus picking a contour that seems to make sense to staff, but is not as defensible. And so that's one of the changes that we're making. In some parts of the county, it may lower the area where this is a requirement, but for the most part, they're generally coincide with each other. The other change that we made is that we're providing an exemption for single-family development on existing lots of record. And the idea is that really this ordinance, the primary target is larger scale commercial development in low-lying areas, where a lot of fill is being brought into a site that begins to alter the landscape. We do realize that there may be isolated incidences where this type of restriction is necessary on single-family lots and on lots of record, but we think that there's going to be more unintended consequences to come out of this than what we think would be the benefit. And we also believe that other standards that the county has, especially with its stormwater manual, address flooding issues in stormwater that would be a concern, for a residential property. So those are really the two big changes. It would still apply to new residential development. So if you're platting new lots, or D.R. Horton is developing a new subdivision, they're going to be limited to these fill restrictions in the areas, the low-lying areas as they're defined in here, but we're exempting the existing lots of record and single-family development on those. Other than that, I'm willing to address any specifics on this ordinance, but it's the same otherwise that you looked at back in March.
I think you have done a really good job with this. Process has been difficult, and I think you've really looked out for a lot of people that could have been affected poorly by it, and I appreciate it.
Yeah, it's much more realistic.
I think it makes a lot of sense.
Mm-hmm.
Thank you.
Any further questions of Rob? Do we have any public speakers for that? Would you please say your name, please?
My name is Juliana Smith. I am the South Coast
yeah.
Project Manager for the Coastal Conservation League. Thanks for letting me back up here again. We are also supportive of this proposed amendment. We worked with the task force and a various group of stakeholders to help bring it to light, and are super appreciative of staff's time to make sure that it's polished and it doesn't have those unintended consequences that we're talking about with your single family or plats. In general, this ordinance is going to encourage more responsible building patterns in the places most likely to flood in our 100-year floodplains. And so that's going to create more resilient structures. It's going to better protect the people who end up working there or living there, investing there later in life. It will also better accommodate marsh migration. This is a natural process that's happening, and it's becoming a faster process as we see the impacts of sea level rise, and marshes are moving into those those low areas that are repeatedly flooded. And this is a really important process in maintaining the existence of our marshes. If we hinder their migration, we lose them because they get too deep, and you lose your grasses, which of course is what is one of the big factors of creating a marshland habitat. These habitats have really invaluable ecosystem services, things that help us combat the impacts of sea level rise and climate change. So they absorb carbon with all of the vegetation that's out there. They're helping to filter our water, which I know is a big issue a lot of residents who live here think about. They buffer storm surges. All of those grasses help absorb those storm surges. And they create a lot of really great biodiversity, some of which we rely on to eat here. And so this policy will help benefit those marshes, and it will also help benefit the people living and working in these low-lying areas. The only concern that we had at the office was perhaps the blanket exemption for single-family plats might be counter to the intent of reducing a reliance on fill. We wondered if there was a way to consider taking it on a case-by-case basis. If the adjacent properties have already been raised, creating an unnatural depression, those single-family plats could also be raised to meet the surrounding elevation. If the adjacent properties are not already developed, have not already been raised, then perhaps that single-family plat would would adhere to this protective policy, which doesn't disallow fill, it just limits how much you could use. So that was something we wanted to put before you all for potential consideration, but otherwise are supportive of moving this forward.
Thanks.
Rob, do you want to address that request?
Yeah, I mean, that's certainly fine. I mean, you know, we could add language at the discretion of the director. I think part of it is that we're trying to limit how much discretionary power, you know, there's that balancing act of giving everything at the discretion of the director, and sometimes that may, anytime you do that, you're adding kind of a level of uncertainty to somebody who wants to build a house. They don't know whether this is going to be something that planning staff's going to allow me to do or not. So if we had conditions on this exemption, I'd want them to be spelled out rather than just saying it that, you know, on a case-by-case basis at the discretion of the director. But, you know, so I guess that would be my only stipulation. If it was the planning commission wanted to, you know, adopt those changes, we'd want to be specific on what types of situations we might be able to exempt single-family development.
Questions? Comments? All right. Can I have a motion, please, to approve Article 5 of the Community Development Code, adding a new Division 513 titled Fill Standards to limit the amount of fill on low-lying areas?
Motion to approve.
Second? All those in favor? Any opposed? It's approved unanimously.
I wanted to thank all of you for, it's a long agenda.
Well, it's not over yet.
Thank you, Rob.
Oh, wait, is there something else?
Yeah, just a couple of items. First of all, I want to thank everybody for the dialogue. I apologize if I slighted.
No, you're fine.
Trying to keep us to a particular format of clarifying questions. And I apologize.
No apology necessary.
I have a couple of things in the chairman's report, if you'll tolerate me for a minute. First of all, you're all aware that Diane Schmelik has retired as a commissioner. If you've gone back and viewed the presentation that was made to her, then I want to express my good wishes and those of yours if she's watching tonight. Best of everything as she moves forward. Certainly appreciate her 23 years plus of service to the county. She did a lot of original things with the Southern Regional Planning and the Northern Regional Planning that now are very important documents to a lot of things that we look at. We'll miss her inputs, but we understand the need. So thank you, Diane. The second thing I'd like to talk about just a second And if there's any objections to this, please let me know. You recall when Mr. Summer was chair, we used to have a half-hour kind of a get-together educational piece. I'd like to reinstitute that because I think there's some positives in terms of providing any educational information or insight that you all have gained or wish to elaborate on to us as an individual. Of course, we can't talk about the agenda, but we can talk about things of mutual interest and concern and education. So I'd like to institute that unless there's an objection to that.
I don't mean to interrupt, but I always liked that it was open to the press. That is, they got a sense of our thinking.
Yeah, because we are assembled as a body,
Right.
you have to allow the
Under
public
FOIA,
in
yeah.
there. So, as you recall, sometimes the lawyer from the other side came in to make sure we weren't doing something incorrectly, or maybe not. I don't know.
But it kept everyone sort of honest, so to speak. I like that.
Absolutely, it's transparency.
Yep.
I want to welcome to the planning department a new, what's your name again? You're so compliant. Welcome, we wish Noah well. He's already been in the newspapers, you probably saw it today. Not for the necessarily positive reason, but he was out there counting the damaged homes that were hit by the tornado, we believe. And we appreciate the service that he had with us. I think he was with us about a year and a half.
Yeah, actually longer. He was, worked at our front desk with zoning permits.
Okay. And we certainly welcome you, Juliana. Your knowledge and your work with the Coastal Conservation League, you will work well with this organization. And we applaud and will support you in any way we can. So thank you for being here.
She may be the first person we've hired who knows the comp plan better than staff, so. Which is unusual.
The last thing I'd like to ask of you, Rob, is you want to say anything about the remaining schedule for the comp plan?
Yes, real quick, and I realize we all want to go home. If you remember, we presented a draft plan in April. We came to you in May and kind of told you the next steps. And we received some public comment at that point that basically kind of gave staff the sense that we really needed to go back into the communities and get some more public input in addition to the input we were already getting with the draft plan. And so, as you remember, at the June meeting, we had our public hearing for the comp plan, but in addition, we had a workshop at Burton Wells Park the following Tuesday, and then that following Thursday, we went to St. Helena Library. We got a lot of good input, a lot of, I would say, scathing criticism, and I like to try to give a positive spin that sometimes the most difficult meetings lead to change or lead to, highlighting necessary changes that we need to consider for something like a comprehensive plan. So I think it's been very helpful. We also had an additional public meeting later on in June with with Councilman Somerville and Councilman Glover, and in addition to the school board representatives and
legislative delegations.
Yeah. And once again, I mean, we were able to really pick up on what some of the pressing issues are, especially in our rural communities, which I think is really the heart of what we do, especially with unincorporated counties. So a lot of good input. Libby Anderson has been really good at taking all of the comments, researching them, contacting other departments. It might not be a planning issue. Maybe it's an issue that has to do with stormwater. But we've been really getting the word out of all the issues that have come up at these meetings. And then what we're doing is distilling them down to what are some major revisions that we see are necessary coming out of the comprehensive plan based on the public input that we've received. So we're going to be finalizing that this month. And what we would like to do in the early August is to have a workshop with the Planning Commission where we could sit down, go over the comments. We will provide the members of the Planning Commission we have a long spreadsheet with all the comments and then also staff recommendation of how we want to deal with these comments, whether they mean an edit to the plan, whether we think that they're already addressed, but maybe in another section. Provide that to you in advance, and then at the meeting, provide our staff recommendation of what changes we think we should make. At that point, everything's on the table in terms of the planning commissioners of what you want to see done to the plan. But our goal is to, after that workshop, get all those edits together, send them on to our consultant so that they could make all the revisions to the plan, so that at the September meeting of the Planning Commission, you have a final plan to look at. We're up against, I would say, a soft deadline, but it's very important to council that they want to see this adopted by the end of 2021. So September puts us in that timeline to do that. But obviously, at any step of the way, as we've learned from the past, when issues come up or somebody has a valid concern about the plan, it's much better to respond than to brush off comments. And so
Absolutely.
that's kind of what we've been.
Applaud the work that you've done. Libby, you're a miracle for us. Thank you for being here.
I mean, I would say Libby has just been so thorough with directing every single comment. What agency is best suited to deal with this question? And I think that's been good because, I think all of us get complacent in what we do, not just planners. And it's always good to know, what the community is concerned about. And then also, we learn a lot from their response. I mean, sometimes there are, programs in place to address a problem. There's some history to it we don't know, but I think all of this has been good in trying to figure out what is at the heart of the changes that we need to make to the plan, or, things that we need to address to take in public comment. So.
Great, thank you.
I think any other comments are going to have to be made in the men's room.
Well, I was just going to say, are there any, thank you, Bob. Is there any other business?
I appreciate it. I know it's a long agenda.
Is there any other business?
New business? Come on. Come on.
If not, I declare this meeting adjourned.
Thank you, sir.